Hello. I will say just a few words about how we intended today, together with Laila, as she correctly said, my former colleague. And so first of all, two words about our guest, Sharon Zagagi-Pinhas. She's a colonel at in the Israel army for a long time, over 20 years. And she has served as a chief military prosecutor. I hope you will tell us more about your career there. And also an interesting fact in your biography is that you have served in several cases before the Supreme Court of Israel, where the court reached some ground-breaking decisions. And we are very interested also about how Israeli Supreme Court works, because it is a different legal system from Latvia, of course. Now about what will be the topics covered today. Of course, it is in a way it is a sad reason why we are together here. It is to commemorate the 7th of October, first of all. And we are here with the author of a project called DINA Project, which is to deal with the aftermath of conflict-related sexual violence, and most importantly, how to react to this and what could be creative outcome of this, how to continue the everyday life, and to bring about the justice after these crimes. And of course, here the audience and me, we will have some questions about the legal approach of prosecution and defense in these types of cases. And also, I'm very curious to learn from your project that you propose a new, more or less new legal concept, and we will be extremely curious and interested about that. But also we are not going to talk only about attack of 7th October, because there are several subjects which interest particularly us here in Latvia, because we also have a very tough, difficult time right now, a time of uncertainty because of the prolonged aggression against Ukraine, and because our neighbor is the Russian Federation, and we also suffer from consequences of this military aggression. And this will be occasion to ask several questions to you: how to organize efficient functioning of the state during these kind of times, and what are the working methods of prosecution to collect, document, and finally present the evidence before the court. So I will, and obviously we want all to hear you most of the time. I also invite our audience, who all of them are highly renowned professionals, so should you have any questions, please also let us know that you want to ask some precisions or questions. So please.
So thank you, everyone. Thank you for inviting me, and thank you for hearing me. It's a great honor to be here, great honor to meet all of you. And I want it to be less of a lecture and more of a conversation between me and you. So if you feel you want to ask any question, something that you want to know, feel free to ask. I'll be talking also about the work of the DINA project, which concerns sexual violence that occurred on October 7 and in captivity. I always try very hard not to use triggering information, because I know this is a very difficult subject. It's difficult for people to hear it. It's triggering. And I want you, first of all, I want to give you full permission if someone feels that it's too triggering or it's too harsh and want to get out and not be here. It's fine by me. I'm not offended. I'm not judgmental. It's fully understood, and I say it every time, at every conversation and lecture that I give. So my name is Sharon. I'm a colonel in the reserve forces, meaning that I've retired from the army, but I still do reserve forces. Now, I was for over 24 years in the prosecution of the IDF. Now in the reserve forces, I'm not in the prosecution. I'm actually in the unit of the defense soldiers for soldiers and combatants for offenses or for when they're suspected of offenses. And after I retired, I did some defending work, but mostly, most of my life I've been a prosecutor, and after I've retired and went to private practice, I specialize mostly in crime victims' rights. And also, one of my most I was very dedicated and most important work, what I consider to be one of my most important works in the IDF prosecution was to adopt the law regarding crime victims' right to the army, because in Israel in 2004 there was a law that established rights for crime victims, and it was not adopted by the army, although the army worked according to the spirit of the law, but didn't adopt the law. It was not in the legal system of the army. So one of my projects, when I retired, the law has passed, and for some years, the IDF has a law of crime victims' rights. So I'll tell you a little bit about the work of the DINA project, and then a little bit about the prosecution, and also the lawyers in the army are part of a body that is called Military Advocate General, the MAG. That's the name I know they're using abroad. In the US, it's Judge Advocate General, but in Israel, it's Military Advocate General, and it has many units, not just prosecution, but also international law unit, and also legislative unit, and also defense unit. And in the prosecution, in the military prosecution, there are two kinds of prosecution. One is prosecution against soldiers that committed offenses and crimes against other soldiers. And the other one is a unit that is in near Jerusalem, and a court near Jerusalem that deals with defendants from Judea and Samaria that committed security offenses. Meaning that when there is a terrorist attack or so on, in the area of Judea and Samaria, then it's treated there. So actually the military prosecution has two phases. The prosecution against soldiers and prosecution in security offenses. It's important to say that the civil system in Israel has also authority to prosecute soldiers for offenses or crimes they committed, and also to try terrorists for security offenses, and I'll elaborate a little bit about it. So I was a prosecutor for many years, over 24 years, and after October 7, we established the DINA project, and the DINA project is constituted of women that are experts in gender and in law. And I wrote this book. I'll leave you a copy of the book, and I'll talk about a little bit about it. I wrote it with Professor Ruth Halperin-Kedari, which is an expert on international law and women's rights, and she was a member of CEDAW in the UN, the Committee Against Discrimination of Women, and with a former judge, retired judge, Nava Ben-Or, which was also in the prosecution, in the civil prosecution in Israel. And when October 7 happened, I always say that when I woke up in the morning at 6:29, it was, I think, you can hear me now. Okay, yeah. 2 days ago, it was 2 years for October 7, and when we woke up at 6:29, it was like being in a movie that you wake up to some nightmare, and then you try to wake up and try to wake up, and when you wake up, you find out that this is the reality. And it felt, to me, it felt like in a movie like a parallel universe, something that we never envisioned, never thought would happen. And the sad thing about it is that it's something that is not new to what happened on October 7, and the sexual violence is not something new to humanity. Sexual violence as a weapon of war existed from the dawn of humanity for many years, and it happened in other arenas around the world, also in Ukraine, also against Yazidi women. And it always seems like it's in a far place, that it will never happen at the country that you are, that is a modern country and democratic country, and how can it happen? But for a fact, it can happen. And I think one of the main problems, and it still is a problem, is that authorities are never ready for it. Meaning they don't have protocols of what to do in case of this attack and in case of an attack that involves sexual violence. Even now in Israel, there are still no protocols of how to deal with it. And I think that the first thing that I say for other countries, that you have to think, you have to be prepared, you have to hope it will never happen to you, but you have to be prepared for this happening, and you have to have protocols, and you have to have knowledge, and you have to train lawyers and prosecution and investigators of how to deal with this kind of crimes, because it's very different from everyday crime. And Nava, which is also, as I said, she is a former judge, and I have prosecuted many cases against soldiers for what we call, and I'm sorry for the word, everyday rape, everyday sexual violence. And I always struggle with the wording, because I feel that saying everyday sexual violence
is the crime worded like this, everyday rape? Is it an official term?
No, it's not an official term. There's rape and sexual violence, and when we saw what happened on October 7, and we thought that we saw everything, and I thought that I was a lawyer for almost 30 years, and I was a prosecutor for 24 years, and I prosecuted many cases, and I thought that I understood everything about sexual violence, about the law, about the evidence, about substantial law. And both of us, there was some point, because we started to work regarding the denialism and silence of other organizations and other countries inside of the sexual violence. And at some point, we realized that even for us, seasoned and very experienced prosecutors, we don't know what sexual violence as a weapon of war. It's nothing like sexual violence that in a domestic law. And we struggled, we wanted to make sure that people understand the difference. So we thought about what word we will be choosing to express the difference. And we're still struggling with the wording, but we chose to call it in our book, everyday, I hate the word, but everyday sexual violence, because everyday sexual violence is very different from sexual violence as a weapon of war. And when you realize it, you have to adapt and to adopt very different system, how to investigate, how to prosecute, how to treat it. And it's a new approach, but it's based on acceptable and old approaches. We used, in our book, we are not inventing anything new. We're not trying to produce some new thesis that was never tried in the world. No, we're not lowering the bar, because we understand that if we lower the bar, nobody will believe us. Nobody will consider our work reliable and will use it. We're using acceptable law doctrines around the world, also in Israel and around the world, to deal with sexual violence as a weapon of war. And why is it different from everyday, as I say? Because everyday sexual violence aims only at the victim. The victim or the survivor is the target of the attack. The autonomy of the survivor is the target of the attack. And in sexual violence as a weapon of war, the aim is not just the individual. The aim is also the community. the attack, the sexual violence, is aimed to harm the community, to instill fear and to instill terror. And because it is sexual violence, it symbolizes the procreation and the continuity of the nation, of the community. So it's not just against a person, it is also against the community. And in October 7, also in other arenas around the world, it was very different because many of the victims have been murdered. And those who didn't die and survived are still coping with very harsh trauma and didn't come forward. And we are used as prosecutors of everyday sexual violence, that the pivot, the center of the case is the testimony of the victim. The victim knows the perpetrator, the victim can say what happened to her, mostly it's women, can identify the perpetrator. And in an attack that is on October 7, and also as in a mass attack, the victims cannot testify and they cannot identify the perpetrator. So we have two difficulties. First, we have no evidence. And because it was in a war zone, the days after October 7 were still a war zone. They were still fighting terrorists. They were still trying to rescue people that were harmed. They were trying to identify the dead people. And so there was no forensic evidence. It's not like when you see, the closing the scene. It's not a crime scene.
Yes, yes. Before you go further, you mentioned the term war zone. Could you explain for us here in Latvia? So, as we understand here, let's say part of the territory, such as Gaza, is under what is called the regime of military occupation, thus the regime of Geneva Conventions and international humanitarian law should apply there. What was the legal regime in the territory where this attacks of 7th October took place?
First of all, I have to rectify. Gaza was not under a military regime, because Gaza was returned to the Palestinians in 2005, and ever since it was sovereign to itself. So it was not under a military regime. Even now, when Israeli army is in Gaza, it's not under formal regime. Just there are it's a war there, but it's not under Israeli regime. And the attack of the Nukhba terrorists was they entered from Gaza to the south of Israel, to the state, to the territory that is the state of Israel, and the attack was aimed at the civil population. And there were directives, orders that were found and intercepted after the attack, and it says expressively, it specifically says that the attack is aimed at the state of Israel and the civil population. So the regime was the Israeli government. It was always a territory of Israel. It was not an area that was part of Gaza before. And when I'm saying war zone, I mean is that terrorists at October 7, at 6:29, thousands of terrorists. There were some waves. I'm talking about mostly about the first wave. Thousands of terrorists, Nukhba terrorists of Hamas. Because when we talk on our doctrine, we're not talking about people that infiltrated later or people that tried to loot or to steal. We're talking just about Hamas terrorists that were trained to invade Israel and were ordered to make an attack. And they were indoctrinized by orders, also by Hamas convention, but also by orders to commit genocide and dehumanization of the Israeli population, of all the population. So they entered the state of Israel, they entered kibbutzim in Israel, they entered a military base, and they also entered a zone where there was a party, a music festival. And actually most of the people that were murdered and a lot of the people that were sexually assaulted were on the festival, on the music festival. So there were thousands of terrorists there, and some of the civil population just fought with them, some with weapons, some with the bare hands. And later on, a few hours later on, the army came and began to battle the terrorists. And for a few days, there were still terrorists in the area of Israel. And then through these days, we know that when we treat a crime scene, what I call a regular or everyday crime scene, you know the exact area, you close it, nobody can enter, you can take, you can do exams, and you can take samples, but it was not possible because there were lots of dead bodies of mostly of women that were sexually assaulted, naked and half naked, some tied, and most of them were executed during the attack, during the sexual attack, or after that. But even though their bodies stayed for many hours and even days in the area, because they were still fighting, there was still Israeli army and also the police, the Israeli police, and also civil citizens that were not in the army that were fighting, and first responders that came to rescue those who were harmed in that attack. So it was, what I mean, a war zone, it's not the regular war zone that we envision in our mind, like a war between two armies or a war in an area that is cordoned just for war. It was in, if I want to make an example, it's like that mass group of terrorists would invade here, the central of Riga, and just act against the civil population. This is why it was so shocking. It started with a missile attack. There were thousands of missiles launched on Israel. I woke up, I don't live in the south of Israel. I woke up from the sirens, and we went to our safe room, to our shelter. And it was after a long time that nothing like this happened. So we realized that something weird is happening. Why is this happening? What happened that there are lots of missiles? And after a few hours, they realized that the missiles were guys for the attack, the physical attack of those Nukhba terrorists that entered the south of Israel and entered all of the kibbutzim, music festival, and so on. And it's not defined, nobody defined it by legislation, but if I'm looking at it, it is more a war zone than, it's not a crime scene. That's what I meant by saying war zone. So I can collect evidence. And if I'm a prosecutor that wants to prosecute people for terrible mass atrocities they committed, I cannot do it because I don't have victims and I don't have forensic evidence. So this is one of the challenges we encountered and try to solve. And it's not, we are looking at the work of the Dinah Project, what happened on October 7th, as a case study for other arenas around the world. First of all, on how to prosecute in other arenas, and second of all, to create protocols that in a country that knows that, hopes that nothing like this happened, but can be prepared to know what to do in case something like this happened.
Then the next question is, the applicable law is Israel national law, and that's it.
First of all, there is a question of regarding the court. First of all, there's always a question on how to prosecute perpetrators, not just in Israel, in other arenas, because there's legal questions that arise. But if you solve the legal question, then there are lots of options for trials. First of all, by the national law, because the attack was on Israel territory, so national law applies. I know that there are some in Israel that think that those terrorists should be tried in military courts, because Israel has civil courts and military courts. As I said, the prosecution in the army prosecute also in military courts. The problem is that there is no military court today that governs the area that the attack happened. There is a court that governs incidents that happened in Judea and Samaria. There was once a court that governed Gaza when Gaza was under Israeli control, but now it was dissolved many years ago, so it doesn't exist. And usually in Israel, the prosecution against terrorists for terror attack that happened on soil of Israel is by national law in civil court, not in military court. So if the there will be an idea to prosecute them. If somebody will want to prosecute those terrorists in military courts, they will have to rebuild a court there was once a court. It was called the Lod court. Lod is one state in Israel, and it was closed also many years ago. So they will have to reestablish it, rebuild it once more.
The reason why I ask you this is I would like to refer to another conflict, and it was what happened in Bosnia and Herzegovina. The thing was that the many different crimes which took place during the war were later tried, and that concerned the executioners of the low level, including sexual violence. So the Bosnian courts tried these people according to national criminal law, for example, article concerning rape or article concerning killing. And the reproach was that this way of prosecuting does not take into account precisely what you mentioned before, that it is not a rape, it is a crime against a bigger community. And this national criminal law section applied in this manner does not allow to take into account the specificity of conflict-related crimes. And that's why I would like to speak now. Could you elaborate on, because that's a part of the DINA project, so how this attack of 7th October is specific and different from all other crimes, and specifically concerning sexual violence?
So I'll say a few things. First of all, sexual violence in conflict is not just rape or severe sexual assault. There is a wide range of acts that in everyday law we do not consider them sexual violence. But as a weapon of war in conflict, sometimes there are acts that has a significance of sexual violence. I'll give an example. We know that some of the hostages that came back from captivity talked about terrorists that wanted to force them to marry Gazans or terrorists, Palestinians. And this forced marriage is also a form of sexual violence. It is not something that is regularly known, because forced marriage is something, first of all, that doesn't happen most of the time in society. And also it has significance that it harms the continuity of the society. Also, forced nudity, parading a person when he's not wearing clothes, looking at a person when he's taking a shower, and forcing a person to wear clothes that are not in his fit. All of them are acts that sometimes are not considered sexual violence and sometimes are not an act. In October 7, for example, we also know that there was sexual violence that happened after the death of the victim. And in Israeli law, there is no law regarding sexual violence against a dead body. And this is something that has to be taken into consideration. So first of all, even in Israeli law, they have, and in other laws, every domestic law has to think of widening the categories of the law. And I think and us lawyers will say that, well, we can't invent new offenses and try for new offenses because of the principle that one can be responsible only for something that was prohibited in the time that he did the act. But I think that it is common knowledge that all of these acts are forbidden. There are something that is forbidden. We're not suggesting that lifting a book is an offense. We're talking about something that is obviously forbidden. Also in the Rome Statute, because we know there's the Rome Statute that it's the laws of the ICC, and it has a definition for sexual violence as crimes against humanity. And even this definition is not fully encompassing every sexual violence. So I think, first of all, there has to be forethought regarding laws in domestic laws and also international laws. And I began to say before, there is a possibility of prosecution in the national in the domestic prosecution system, but also they can be base for prosecution in international laws. And also there are countries, for example, in Europe that are part of the Rome Statute, part of they signed the Rome Statute and part of the ICC, and they have universal jurisdiction over certain crimes, such as crime against humanity. So, for example, a country like, I don't know, Spain or Netherlands or even the UK have authority in their laws to prosecute for crimes against humanity, even if the crime did not occur on their land. So there has to be given thought for this. I think that the prosecution should be in the country that the crimes were made, but I think there is also a possibility of trying in other places, in other countries, and also, of course, civil suits. And in our book, because most of us came from criminal law, I call ourselves the criminalists, we know that the criminal law is the strictest of all systems, meaning we have to prove something beyond reasonable doubt, meaning the rules are very strict. And we're saying that if we build a base for criminal proceedings that are so severe, then it is a base for other proceedings, because we know that other proceedings and systems have lower bar level, such as civil suits, international suit, and this is also something that we try to achieve in our book.
Exactly, and in your book you propose something, well, you will have the possibility to tell us if it's new or not so new, but what is striking me is that you suggest that there should be principle of collective responsibility, and you explain you suggest that it, if I understand correctly, it exists more or less already under the term of common criminal enterprise. So is it the same or something new?
First of all, we do not call it, I want to emphasize, I always find myself being very accurate. It's not collective responsibility, because I always give it's joint responsibility, because collective for lots of us, it's different. Collective, like we all know, collective punishment, when there is say a classroom and some student does something that is wrong, so everybody gets punished. This is not this principle. What we're saying, joint enterprise means that if we have a group, it's like a lynch mob or like a robbery. A group went to rob a bank, and one of them, during the robbery, one of the robbers shot and killed the teller. Then we can, in criminal law, in many systems, also in Israeli system, also in the US, also in other systems, we can try all of the collaborators, all of the people that were in this group for the killing or for the murder of this teller. Why? Because they all willingly took part in this enterprise. They all knew what they were doing, and they all could foresee and expect that such an outcome can be in the realm of reasonable or foreseeability. So what we're saying, and when we're taking it to a mass attack, and we know that October 7 attack was a mass attack by thousands of terrorists that were indoctrinated by principles of genocide and dehumanization, meaning that they treated the population they were attacking as they had no rights. They were not living people. They can do everything. Everything was permitted. Nothing was prohibited. And when someone chooses to be part of this group that was indoctrinated, and the elements are, first of all, choosing to be a part of this group, being a group, and knowing and accepting the indoctrination under the work of this group, meaning that they knew that it was aimed at genocide. Every act was okay for them, and of course, in that way, it could foresee everything that happened. And this is one point that we're talking about regarding the joint responsibility. That is why I'm stressing that if we know that the attack was in waves, and at some point, for example, people entered Israel and stole televisions, stole cars. We're not aiming our argument at them. It doesn't mean that they should not be indicted, but not for the sexual violence. We are aiming our doctrine, our thesis, just to those who enter the attack with this indoctrination. Because if a certain random person entered Israel and did not know that it was indoctrinated, what was the indoctrination, what were the orders, he didn't know it, then I cannot use this doctrine. I'm using it only on those who joined the attack. There's a question from the...
Short question, does it work in practice, or how it work in practice to like prosecute a unit? You know, the unit was there, so we know the people, so actually this concept of a joint liability like kind of could work, but about the practice. And second short question, you said there is like civil criminal courts and military criminal courts. We don't have them, so maybe you can in short explain what is the difference. Maybe there is no appeals or something like this, I don't know.
Start with the last question. First of all, they're the same courts, they have appeals, they work by the same laws. Just the difference, first of all, is the focus of the courts. As I said, military criminal courts focused on two populations. There are different courts. One system focuses on soldiers that commit offenses against other soldiers, and the other one against terrorists that committed offenses or crimes that are related that are security offenses that are related to Judea and Samaria. And second of all, the civil state in Israel has, also has authority on all of the subjects that I specified here. When you have to decide if you're going for, let's say, for example, that a soldier robbed another person, then we have to examine if there is proximity from what happened to the army. If a soldier robbed a pharmacy, and he robbed the pharmacy and he was not wearing a uniform, and he did it just because he wanted to rob it, and the fact that he's a soldier is just random, then you try it in the civil system. But if there is an affinity, there is proximity to the service, like let's say a soldier is raping another soldier that he met in his unit, or he does it in his unit, then there is a proximity for the service, for the military service, and that's why it will be tried in the army. So the system have the same laws, the system have the same methods, they work the same. The judges in this system have to go through the same training as civil and military. Just it differentiates by the jurisdiction or subjects of jurisdiction. That's how you know. Sometimes there are questions. I remember when I was chief military prosecutor, I used to get questions. There was a terror attack in Tel Aviv, somewhere in Tel Aviv, and there was a question: where will the terrorist be tried, whether in civil court or in military court? And we have to examine all of the circumstances of what happened to see which one falls under the most proximity. Like from where, if the terrorist was from Judea and Samaria, if the planning was there, or if the old act was in Tel Aviv and not in Judea and Samaria. So there's so many questions, and then sometimes like in other authorities can decide, and then they go to the Attorney General, and then he makes the decision. But they're the same, and they work by the same laws. They have appeal. They are the same penal code, and so on. Regarding how we envision the prosecution of many people, what we envision is like when we want to try a group that went to rob a bank and something like this happened. It's a joint indictment that specifies everyone's action in a certain arena, but also specified in great detail what happened in this arena, the indoctrination, all the facts that needed to be gathered in order to prove that this was a joint attack. Otherwise, there is no, we have to prove it. I just can't go with the indictment and not prove all the elements that I'm saying. If I say that certain elements, all of them together, piece together the indictment, that I have to write them in the indictment and prove them.
It is maybe not your specialty, but under these military tribunal, is there also defense lawyer?
Yes, in both of them. In the court of soldiers, there is a special unit in the military advocate general in the army that concentrates on defense. As I said, in reserve forces, I'm part of this unit. So sometimes I mostly give consultation. I do not appear in court in the defense. And in the other courts in Judea and Samaria, there are, of course, lawyers. Civil lawyers, there are certain groups that provide defense lawyers. And of course, I'm saying that if there will be prosecution against Nukhba terrorists, they should be conducted by law, with no shortcuts, with defense attorneys and by the law.
If you were to give advice to us here in Latvia, because as you correctly said, we don't have a very strict separation for now, but also because we don't have, at least for the moment, very severe necessity for that. But would you say that it should be a model, the Israeli system of separating two judiciary orders?
First of all, I think there should be a separation. I think that there should be a separation, but I think that when you want to, sometimes military tribunal has bad names for no reason. When you try someone at the military tribunal and you know it works perfectly by the law and by all the rules, but others perceive it as something that is military, and of course it's not going by the book and so on. But I think that in certain cases, like when I'm talking about courts for soldiers that commit offenses against other soldiers, the system in Israel, if you try a citizen, there is a judge, or sometimes 3 judges. In the army, there is a judge, but the judge is accompanied by 2 officers from the command that the soldier is part of. This is a small from the. It remained from the, because the Israeli law was built on British law, and there is the jury system, which does not exist in Israel, but in a small way in military courts against soldiers, the tribunal consists of 1 or 2 professional judges, lawyers, and the third one, or if it's 2, are officers. That they're laymen. They're not because the idea was that if you try a soldier, then you have to be in his shoes. You cannot understand the specifics and the things that are. Sometimes there are special needs, and sometimes you have to understand where to understand the surrounding. So this is, but in courts of terrorists in Judea and Samaria of security offenses, then there are just judges, not laymen, just professional judges.
And could you tell us also about prosecution? In Latvia, prosecution is under judiciary, so it is like a part of magistrates. In many other countries, it depends from the Ministry of Interior. How is this in Israel?
In Israel, it's not in the inquisitory system; it's the adversary system. When there is a prosecution and there is the defense, sometimes there is a public defender in the civil courts. Sometimes, but mostly lawyers that are defense lawyers, private defense lawyers, and the courts are an independent unit under the. It's not even under the. It's not under the Ministry of Laws, but under a specific unit that it's called the courts unit or something like courts tribunals, and the head of it is the head of the Supreme Court in Israel.
Very well. I suggest that we, if there is anything we should still address about the DENA project, and
Yes. So I told you before about the challenges, but I haven't given all of the solutions. One of the solutions is, of course, as I said, because we cannot link a certain perpetrator to a certain victim. And so one of the solutions is the joint responsibility. When you do not have to link, and you do not have to identify a perpetrator, you just have to prove that he was part of a group. The other one, as I said, that sexual violence as a weapon of war is also aimed at the community. And one way to emphasize, to amplify what you're doing is to do it outdoors. And that differentiates it from everyday sexual violence, because everyday sexual violence happens indoors. It's always the word of the victim against the perpetrator, but sexual violence as a weapon of war is done a lot of time outdoors in front of witnesses, people that see it from the community, so they can see and they can spread the message and they can be afraid. And that's why in October 7, as opposed to everyday cases, there are lots of eyewitnesses, people that saw with their eyes sexual violence, and also we call them ear witnesses. We do not mean hearsay, we mean ear witnesses, people that heard with their ears sexual assault. And we have safeguards to make sure that, because something that you hear with your ears, you can claim that maybe it's something else and so on. So we also give safeguards to make sure that it's proving sexual assault. Also, we're using res gesta evidence. Res gesta is a testimony of the victim in real time when he relays what happened to him to someone, which is an exception to the rule of hearsay. And usually those are legitimate testimonies. Just in everyday sexual violence, the authorities just tend to rely on the testimony of the victim and do not look for this evidence. But in these cases, we are trying to look for this evidence, and they do exist because a lot of the sexual violence was done outdoors. A lot of the victims were left dead and for the world to see. And the other thing that we are talking about is premeditation, the forethought. What was the plan? How can we prove that the plan was also to use sexual violence? Because we know that in October 7, but also in other arenas around the world, you do not tend to find evidence of an aim to use sexual violence. We know from researchers that we read that in the Ukraine, in the beginning, they were able to prosecute Russian soldiers for sexual violence because they filmed themselves doing it. Later on, when they realized that it was evidence, they will stop filming it. So in most arenas, you will not find evidence even for the premeditation. But what we are saying, and the findings in our book, first of all, what I want also to say, we are not the government. It's something that I said in the beginning. We are not the government. We're not part of the government. We're independent. We're an independent group that works under the academy, under the Bar Ilan University, Rachman Center, the Rights of Women, we're also not an archive and not an organization that collects evidence. We did not collect evidence because there is an ongoing investigation by the police. And as lawyers, we know that if you interfere and you take evidence, you're interfering with the investigation. But what we did is that after October 7, a lot of information surfaced. There was a lot of public information regarding sexual violence. We monitored all available information. We put it in a platform. We put it in a table that we categorized and cataloged all the evidence by its proximity to what happened. And we analyzed every item of the evidence. And when we thought that some part of evidence is something that we cannot rely on, we took it out of the platform. We didn't use it. And in our research, we found that in 6 arenas in the south of Israel was widespread sexual violence. We found sexual violence that were cases of sexual violence that were similar to one another with distinct characteristics. And we know from laws that when we find something that is similar in different places, distinct things, not just random things, but distinct things, that it can be proof, and that's what we're suggesting, proof of forethought. Because when you find in 6 arenas bodies of women that are stripped or half stripped and mutilated and sexually assaulted and then dead, then it cannot be a decision of a random terrorist that in this arena decided to do it. Because if you find it in different arenas, it cannot be coincidence. This is a clear sign of premeditation, and this is also something that we suggest in our book.
Exactly. I wanted to ask here about the notion of plan, because usually the prosecutors don't like the idea of proving a plan, because that is probably the toughest thing to do. And by the way, in the definition of crime against humanity, the idea of establishing a plan was abandoned. You don't need a plan to establish a crime for humanity. But as you correctly said, there are many patterns which are repeated. So what were you weighing for or against the proving of a plan when you elaborated your project?
First of all, I have to say that as a lawyer, when I was in the military prosecution, I always tried to break the borders, to be creative and not just to stick to formalities. And after when I retired and I started to represent crime victims, and I saw other systems, and also I saw it in the military system, that were very formalic, and they always tend to go with what I call like in basketball, slam dunk, or something that is a sure conviction, and not try the complicated things. And I think that conflict-related sexual violence is the complicated thing. It's never simple. And when we look in other arenas around the world, we see that there are very few indictments. And the reason for it is that it's a challenging area of laws. I think it's an area, we call it atrocity law, that needs to be developed. Needs to be developed by naming offenses, elaborating which evidence to look for, maybe widen understanding the characteristics, and then try to bring solutions that accommodate those challenges.
Yes, thank you for this remark, because I would like you to explain us what is the future of your project, in the sense how it could be applied to other situations around the globe. I'll give you an example. You just mentioned Ukraine, and indeed, speaking about Ukraine, there is a very specific sexual-related crimes happening at the very moment. It is the sexual crimes against prisoners of war, and there is currently a report made by the United Nations establishing that around 80% of prisoners of war are submitted to sexual violence, different types of it. And what is striking me is the report establishes, as you said, patterns. There are patterns which seem to indicate that there is a plan, or probably a command from a higher military hierarchy. So how would this how would you apply your project to other situations outside Israel?
Let's say, for example, you try to look for the indoctrination for the attacks. Let's say there is an attack in other arenas, see what were the orders, what the indoctrination, put your hands on the directive in order to see what was planned, first of all. It goes for intent. And then exactly to look for, you have to look at everything, the smaller crimes, but also the environmental context. You have to always to look at the context, because the context sometimes gives you the meaning that you do not have without it. Let's say if we're talking about sexual violence against prisoner of war in Ukraine, if you see it's a widespread phenomena, if you see distinct characteristics of these attacks, if you see, let's just say you see also declaration by those who hold those prisoners of war regarding to their fate and so on, then you can build a case on it. But you always have to look for two things. First, what the specific for a certain victim, but also the context of what happened in general. You have to see how it, what is influence on the, let's just say, in October 7, when we have a witness that said that he saw a rape. And you can say, okay, he is a witness, just one witness. How do you corroborate what he says? Although we know that when we're not talking about identification, eyewitness can be reliable by itself. But if you find that in other arenas there are same phenomena, the same acts, then it can also be used not just to build what happened, but to corroborate his testimony. Meaning the context of what happened, not just to a certain person, but for the whole community. You take pieces of the puzzle, and when you're piecing them together, the context can also give meaning to the intent, can also give corroboration to the testimonies, and so on.
So you invite the prosecution to think in new, innovative ways also.
I don't think it's innovative. I think it is bold. It is something that exists. It is something that is challenging. It's always easy to go on the easy way, but they have to be bold, to take bold choices, to go all through, to go and to look for legal solutions. And sometimes I encounter, not in these cases, but in other cases of prosecution, I encounter prosecutions that are not bold, that do not look for a solution to challenges, that choose to adhere to certain things and not try, because the law is something that develops, and we have to adapt the law to the change of humanity. And sometimes I see prosecution, not in this subject, but I see prosecution that go back instead of going forward.
In the remaining time, I would like to use your very valuable expertise for the benefit of Latvia, because we all know that Israel is very well prepared for the things you cannot be really prepared for. So what would be your advice how the legal system, including the prosecution, should be prepared for, let's say, widespread attacks, whatever the name of it, war, criminal attack, etc.?
First of all, I invite them to read our book, because we're offering one of our calls. I didn't say it before, but we have calls for action for certain actions. First one was for the UN to call Hamas as an entity that uses weapon of war, sexual violence as a weapon of war, and we succeeded because in August, Secretary General of the UN declared Hamas as an organization that uses sexual violence as a weapon of war. And then we call to the prosecution of Israel to prosecute, but we also call for the establishment of training for prosecutors and investigators. First of all, to explain to them what is, if we're talking about sexual violence as a weapon of war, what is the sexual violence, how it is different from everyday violence, what's its characteristics, and then, first of all, they know the phenomena, and then try to develop solutions for maybe to widen the law, the penal code, with more offenses. Train them to know how to look for, what to look for, which to do not expect, as I said, it's very rare that you have victims' testimony. So don't go look for it. Go look for other things. Look for eyewitnesses. Look for ear witnesses. Look for first responders that took pictures. look for other evidence, and try and find, it's very important to find evidence regarding the intent of the attack. So this should be in a protocol, meaning if something horrendous happened, then you don't have to stop and think what to do. You already have the protocols, and and those units of prosecutors and investigators are all trained and know what to do because they understand, and they're not wasting their time trying to deal with challenges, but they know how to handle the challenges. It's also, by the way, true to treatment of survivors, of course, because also, but in this subject there is the Morad Code, Nadia Morad, which is a survivor Yazidi woman, and the Morad Code gives a code of how to treat survivors of sexual violence. It has some, and I think also that in every country, it's important to know the codes and the protocols, because there are international codes and protocols. Also, the UK has a protocol against sexual violence, and I remember when we started to work, we knew nothing of it. So it's also important to know all of the legal resources that are at the prosecutors and investigators' disposal.
So the first thing would be to elaborate a protocol. Let's say, first of all, what is the protocol in case of a terroristic attack, military attack, and then you could go more specifically into other protocols such as sexual violence. And
I think it's possible. I think when you understand that there is a possibility that you will have to indict people, if you're talking about in a legal perspective, because maybe in other cases that they will, I don't know, will not indict. But if you're looking from a legal perspective, then you have to understand what the attack is, because the challenges, our doctrine gives the opportunity to prove sexual violence, to link the perpetrator to sexual violence, but you can also link perpetrators to other crimes that were committed in the attack. If someone is joining an attack that is indoctrinated to do this and that, and you can, and it entails everything, that you can also indict him for this. So you have to look for it.
Could you also explain us another aspect of this? We are here very used to that, well, we live everyday life, and during the everyday life, well, the institutions work better or worse, but they work. During an attack, there is a problem of contingency. What is the Israel has a lot of experience with this. Could you give us some advice? What should be these contingency protocols?
First of all, I don't know, although Israel has faced many challenges, I don't know that it has contingencies. Just can rely on experience. Because when October 7 erupted, there came generals that were retired from the army and were and fought before, and they helped navigate it. But I'm not sure that there are. I think in many countries there are no contingencies to what to do. In a small part, I remember when I was chief military prosecutor, the thing that I hated the most is I had one officer, and with all of our stress and legal trials and so on, we sat for weeks to write contingencies protocol for the prosecution in case of a crisis. And we hated this. It's a very boring and tedious and specific job. But when there was a war later on, I said, I never believed when we were building those protocols, they were not related to sexual violence. Just protocol, what do you do in case of an emergency in the prosecution? How do you change what you're trying? What do you do with the people that are detained? And so on. And when October 7 happened, I said to myself that when we wrote those protocols, I never envisioned that they will be used in any. It seems like we're doing something that was for nothing. But in effect, it was something that was based for how to deal with things. So I think that it's like climate crisis. You talk about it, you know it can happen, but you do nothing. Things that are not feasible and they have no existence in reality. People tend, and societies and organization, authorities tend not to postpone to later on. And I think authorities should allocate resources to plan for things even if they do not seem tangible at a certain moment. This is the biggest challenge of all, to try to be prepared for something, for a catastrophe that you think that will never happen, but obviously can.
So this is a perfect example that protocols do work, and if anyone has any question, please do not hesitate.
Yes, I have a question regarding Iran. As far as I know, you still have a conflict with Iran, and if we compare it with Latvia, actually it's very similar relationship between Latvia and Russia or Belarus. In last few years, we have had several incidents regarding arsons. Also, we have had drones in our territory. Also, there was an incident regarding damaging of cable in the Baltic Sea. And the question actually is, how do you qualify some kind of attacks against your infrastructure that are being organized by Iran's secret services, intelligence services, etc. Because in our country, in Latvia right now, we face with challenges that we see that it's being organized by GRU, Russian military intelligence services, but we qualify these actions as just intent damage or something like that, but not terrorist, like a terrorist attacks. And from your point of view, whether it is possible to qualify such attacks as terrorism, as a state-sponsored terrorism? That's the question. Thank you.
I myself didn't deal with this subject, but I'm pretty sure that the secret services of Iran, or country that is danger to Israel, and the danger to infrastructures and so on, that there were attempts also we had a war in June. We were in shelters. There was a lot of damage in June. And I'm pretty sure, although it's not part of what I do, I'm pretty sure that it's one of the main subjects that is being dealt in the IDF, trying to foresee what happened and trying to be prepared for it. But also when something like this happened, there was a lot of damage that was done by missiles. And I read in the newspaper that just a few days ago there was a cyber attack on a hospital in Israel, and it was attributed to Iranian secret services. So this is a subject that I don't know in person, but I'm pretty sure that this is one of the main things on the agenda of the IDF.
But do you qualify as a terror attack, or what is it from your legal perspective?
I think it's a big question that I'm not sure that I'm an expert in it.
I have also a question regarding admissibility of evidence that has been obtained during intelligence actions. As far as I know, Israel is quite popular in this field. You have created such tools as Pegasus, Kandiru, etc., like tools for espionage. And the question is it allowed to use it in your criminal cases as evidence, or it is only for intelligence purposes?
First of all, I think Pegasus is not governmental venture, but from Israelis, but I think it's not by the government. There are strict rules in Israel regarding, in criminal law especially, admissibility. First of all, the simplest example is if a terrorist is detained by military and is investigated by military and gives some information, and then there is a trial. The trial usually cannot rely on what he said in his security debriefing or inquiry by the army, but the terrorist must be brought to the police, and then he has to be investigated by the police. So I cannot use testimony that is given to security when he is captured. This is first. And the second of all, there is a strict law in Israel regarding the use of those tools, regarding breach of privacy, regarding listening to someone. There are laws. There are laws again, and it has to be admissible. Otherwise, we cannot use it. I think mostly if people using it, it's for intelligence reason, to find out, to prevent something. But they are not used. Mostly, they are not used in court, not in criminal laws.
Question regarding defense attorneys. So you mentioned that the defense attorneys, as far as I understand, are in military court. They're state authorities and paid by state, or different.
If I'm talking about courts against soldiers, there is a military unit that gives defense to soldiers, but a soldier can opt, he can choose if he wants to go with the military unit, the defense unit, which is, by the way, they're very good because they're very experienced, or he can choose and he can pay for a lawyer that he chooses by his own choice. And as part of my work, I don't do a lot of work in the as a defense attorney, but as part of my work, I gave consultation in my reserved capacities in the unit of the defense, and also as a private lawyer. Someone that approached me and wanted to hire me, and then I represented. So it's by choice, and in the courts against terrorists, I know that they can also hire any lawyer they want, but I know that there is a certain group that gives them services without paying. Group organization, not by the Israeli government.
Thanks. And second short question about the level of evidence. You said that in military crimes, the level of evidence probably should be lower. I kind of agree, but all the time.
I didn't say it. In military, the level has to be. It's strict.
Let's then discuss it. Yeah, because the evidence, of course, you cannot collect as in as in civil criminal case because, as you said, the witnesses are dead and so on. So probably the level of evidence is, at the end of the day, it is lower. But of course, the question is that when there is a prosecution, it means that some state has caught the persons from other citizens of other state and try to prosecute. And then, of course, the question arises for me: how low this level of evidence could be? Where is the bottom?
So I disagree. I don't think it's low. I think that if for example, you're bringing, and in our book we found that there are 17 witnesses that witnessed by their eyes rape and gang rape. And if you bring testimonies from these 17 witnesses, and you, first of all, and they're talking about 15, what we wanted to make sure is that we're not talking about 17 witnesses that talk about one case, because that way it's one case. So we made sure we took a lot of research to understand if these cases are one case or many cases, and we got to the conclusion that 17 witnesses are talking about at least 15 cases. So first of all, each witness can testify for what he saw or heard, and then each witness testimony can corroborate the other one testimony because it correlates. So it does not lower. On the contrary, there is a chapter in our book that we call safeguards, that we're suggesting to use evidence in order to certain evidence in order to safeguard the possibility. We do not want to lower the bar. For example, it's also what you asked me. We know that in the Israeli media there were two coverage stories regarding testimony for two terrorists that admitted that they used sexual violence. Okay, first of all, I don't have this testimony, so I cannot see if I cannot give my opinion. So if in order to make my opinion, if a testimony can be reliable, I have to see all the testimony. I did not have access to this, so I didn't use something that I could not rely on. Second of all, those testimonies were given to security forces. And security forces, as I said, is something that we're not relying on in the Israeli law. If I want to use this evidence, I have to have the terrorist give testimony to an investigator and to take all the content from the investigation. And I chose not to use it because I think it doesn't stand on its feet. So we are not asking to lower the bar, because if we're lowering the bar, we achieve nothing. It's a puzzle that we're asking to piece together, and it's very difficult, very specific. You have to use many parts, but in the end, we hope that the collection of all the parts will bring to a solid basis and not to something that lower the bar.
I just wanted to add that it's more like looking wiser, not to lower the bar for the evidence, but looking wiser and be, as you said, be bolder. Yeah.
Exactly. So it's a good thing you gave her a microphone.
Anyone else in the audience?
I have a question about the protocols. How we need to think when we write them. Maybe you can suggest something. How we need to think when we write those protocols. Can you suggest something?
Yes, I think that the protocol should be done by a group of special experts in laws, in different kinds of law, not just criminal law, therapists. It should be interdisciplinary, and it should be based on work that has been done before on, as I said, sexual violence as a weapon of war, on work that's done before. We have to find it, and then I would suggest maybe establishing a committee or a group that would work to legislate it, or write the protocols, and they should meet with experts from around the world, try to map the challenges, try to see. And we, in a book, we're hoping to give a roadmap that everyone that reads the book understand the challenges, understand the solutions, and understand how to build it. And of course, if someone wants to use our assistant, then is most welcome.
Anyone else a question? Maybe a last thing. So it is not a question. Do I understand correctly that your book is also a PDF freely available on the internet?
Yes, the book is in PDF. Here, I will give you the book. I brought you a gift from us. Here in the back of the book, we have a website. We established a website that is called the Dinah Project. And this is the barcode of the website. And the website, first of all, has many resources regarding sexual violence as a weapon of war. It can also be a website for someone who wants to learn and to, there are a lot of resources there, decision articles and so on. Also, one of our visions is to try and find a creative vision that makes the difficult subject accessible for the public. If you see in our book, you see this is a creation, an artistic creation by an Israeli artist named Zoya Tzerkassky. This is of the Nova Festival. And we try to use graphics and infographics in our website and in the book that are more accessible to understand the subject. And of course, in the website, there is also, first of all, a link for the book. It's in PDF. And second of all, there is also, I think there is a summary and questions and answers regarding the book, and I will leave you, of course, a copy here.
Well, with this, if there are no any other questions, I think we have done the round of all the questions. We understand that we have many things to do here in Latvia, thinking about these problematics. Of course, we also I have to say Latvia did not ignore the 7th of October. In this sad anniversary, there were lots of press articles about. So not only the legal professionals, but also the general public knows what happened. And this is a very valuable project for all of us.
And first, I have to say that the good thing that I have to say today, I started the day when I woke up in the morning and I saw that there is an agreement to stop the war, cease fire, and to bring the hostages back. So for us in Israel, after what was very difficult 2 years, we're hoping for change, for the cease of the war, and for everything to return to safety and normality.